In 1971, the New York Times took the United States government to the Supreme Court because Richard Nixon had claimed executive authority to force the Times to suspend publication of classified information in its possession. The question before the court was whether constitutional freedom of the press, guaranteed by the First Amendment, was subordinate to a claimed need of the executive branch of government to maintain the secrecy of information. Section 793 of the Espionage Act was cited by Attorney General John N. Mitchell as cause for the United States to sue to bar further publication of stories based upon the Pentagon Papers, which were military movements in Vietnam. The statute was spread over 3 pages of the United States Code annotated, and the only part that appeared to apply to the Times was Section 93E, which made it criminal for whoever shall have unauthorized possession of access to or control over any document, writing, code, book, symbol, etc., or note relating to the national defense or information related to the national defense with information the possessor has reason to believe could be used to the interest of the United States or the advantage of any foreign nation willfully communicates, delivers, transmits, or causes to be communicated, delivered, or transmitted, or attempts to communicate, deliver, transmit, or cause to be communicated, delivered, or transmitted, the same to any person not entitled to receive it or willfully remains the same and fails to deliver it to the officer or the employee of the United States entitled to receive it. In the 6-3 decision, the Supreme Court agreed with the 2 lower courts which had originally decided that the government had not met its heavy burden to showing a justification for prior restraint. The court issued a very brief peer-to-real opinion stating only that the court concurred with the decision of the 2 lower courts to reject the government's request for an injunction. The justices' opinions included different reasons of support for the clear superiority of the First Amendment, and no justice fully supported the government's case. Because of these factors, no clear and exclusive verdict appeared to have come out of this case.
In 1967, an interracial couple left their state of Virginia to get married. They went to, I can't remember where it was, but they left the state. When they returned, they were sentenced to 2 years in a state penitentiary because they were married and they were interracial. The judge's decision, his justification was the following. Quote, Almighty God created the races white, black, yellow, Malay, and red, and he placed them on separate continents. And but for the interference with this arrangement, there would be no cause for such marriages. The fact that he separated the races shows that he did not intend for the races to mix. Although this reasoning wasn't exactly racist against one race, it was actually discriminatory. Loving versus Virginia is a really influential case because it gives a great example of what the 14th Amendment actually includes. Discrimination is an issue that many people have had to face, whether it be based on race, religion, gender, or sexual preference. This case can still be influential today because it sets a precedent when looking at other issues about discrimination, such as whether or not the same-sex couples should be able to get married.
This case brought about lesser power than the national government could have. If the court had overturned the 2 lower court decisions that were which were in favor of the New York Times, the entire course of history could have changed. Since Richard Nixon was president at the time, he could have censored any attempts by media or persons to influence decisions of the Watergate scandal. He may have never been impeached. Comparing gay marriage and interracial marriage is a fallacy and should not be there. Every discriminatory law in history has been repealed in the United States. Virginia was the last state in the country to have an interracial law. Every other state had already repealed it. New York Times versus United States is much more pertinent today. It barred the government from censoring the media, which could censor many things today, including WikiLeaks, which is obviously much more pertinent to today's history.
President would want to block these papers. If the government didn't want them out, there was clearly a together interracially. His case, you can see why the government wouldn't